Welcome to The Explainer. So, imagine if the strict letter of the law accidentally legalized pure chaos. Today, we're diving into a really fascinating legal safety valve. We're looking at how courts interpret statutes when the literal words break down, defy all logic, and basically threaten to turn society upside down. We are talking about the golden rule of statutory interpretation, which takes us way beyond mere literalism.
Okay, to really get this, we need to contrast two totally different judicial philosophies. On one hand, you have the literal rule. Under this incredibly strict framework, a judge is purely the mouthpiece of the law, applying the plain grammatical meaning of the text, literally no matter what happens. But on the other hand, you have the golden rule. This acts as a vital secondary step, a safety valve, if you will. It empowers the judiciary to step in and start ironing out the creases when that rigid, black-letter approach leads to a consequence the legislature simply couldn't have intended.
All right, here is our roadmap for today. 1. The limits of literalism. 2. Triggering the golden rule. 3. Ironing out legal creases. And finally, 4. Guardrails against judicial overreach.
Let's jump right into Section 1, the limits of literalism. This is all about what happens when words break down. So strict literalism demands that we follow the plain meaning of a text. But sometimes that plain meaning produces an outcome that is just logically inconsistent or manifestly absurd. When this happens, a strict reading can make a law completely futile, turning it into what lawyers call a dead letter. Think of it kind of like a massive software glitch in our legal code. If left unpatched, the whole system fails its original purpose and the legal order just breaks down.
Moving on to Section 2, triggering the golden rule, and how exactly courts go about fixing these broken statutes.
This whole concept actually stems from a very famous definition, Lord Wensleydale's dictum in the landmark 1857 case, Gray v. Pearson. This foundational rule establishes that the grammatical meaning of a statute should absolutely be followed unless it leads to an absurdity or an inconsistency so massive that the original intention of the legislature must be different from what the actual words say. That repugnant absurdity, that is your trigger.
But courts can't just do whatever they want. Because this is the law, judges have to follow a predictable two-stage mechanical process. Step 1 is your literal starting point, adhering to the ordinary sense of the words. Step 2 is hitting that absurdity threshold. And a quick note for any law students out there, absurdity is not just an outcome a judge personally dislikes. The result has to be logically impossible to reconcile with the statute's overarching objective. Once triggered, courts use two hidden patterns to fix it. There's the narrow application, where they pick between two existing meanings of a word to avoid chaos, and then there's the much rarer broad application, where they might actually modify the text to fix a glaring drafting error. But the golden rule here, pun intended, is to resolve the absurdity but go absolutely no further.
Let's get into Section 3, ironing out legal creases. We're going to look at how this mechanism actually solves real court case puzzles.
Okay, imagine showing up to work, only to find out you've been secretly transferred to an entirely different corporation without anyone asking your permission. Well, that was Mr. Noakes' reality back in 1940. He worked for a company called Hickleton, which got amalgamated into a new company, Doncaster, by a court order. Noakes was totally unaware of this structural change, and he skipped work one day. The wild thing? He was penalized 60 shillings for absenteeism by the new company. The new company's argument was that under the Companies Act, all assets, properties, and liabilities, including employment contracts, were automatically transferred to them.
Now, a strict literal interpretation of the Companies Act would have backed the corporation for sure. But Viking Simon powerfully applied the golden rule here. He pointed out that a literal interpretation would lead to a completely absurd legal outcome where a human worker is treated like property, basically like chattel. He argued that citizens have a fundamental right to choose their employer, and a plain reading would totally override that freedom. So the court successfully corrected the literal reading to prevent a genuinely repugnant result. And this perfectly illustrates how courts close those massive literalist loopholes. It's a classic legal puzzle. Actually, if you're tackling an exam problem, like the famous landmark preservation scenario where physical labor can't be forced on a company, this is exactly how you handle it strategically. In this 2005 Standard Chartered Bank case, the bank was prosecuted for violating a statute demanding both imprisonment and a fine. The literal rule logic goes like this. You can't put a corporation in a jail cell, therefore the entire sentence is impossible, so the fine must fail too. No way, says the golden rule. The court ruled that the absurdity of granting a corporation total immunity just because they can't go to prison means we pivot. Impossible imprisonment doesn't mean the fine gets ignored. They interpreted it in a way that maintained the law's integrity without crossing into judicial activism. Another classic pattern involves resolving broad ambiguity. We see this in the 1957 tax evasion case of Sodra Devi. The court faced a really fascinating puzzle here. Under the Income Tax Act of 1922, computing the income of an individual had to include the income of their minor child or wife. But wait, does the broad word individual include a mother adding her child's income to her own? Well, a 1936 tax inquiry report revealed the actual legislative intent. This provision was originally drafted specifically to curb the rampant evil of husbands and fathers evading tax by transferring assets to their dependents.
Because the legislation was so clearly targeting tax-evading fathers, the court used the Golden Rule's narrow application to restrict the interpretation. They ruled that the word individual in this specific context refers only to a male or father. Interestingly, though, Justice S.K. Das delivered a dissenting opinion, arguing for a strict, literal reading that would include both men and women. It just goes to show how incredibly contentious stepping away from the black letter of the law can actually be.
Finally, Section 4. Guardrails against judicial overreach. We need to talk about the strict boundaries here.
With this immense power comes a very delicate balancing act. We have to constantly distinguish between interpretation, which is finding the hidden legislative intent, and legislation, which is when a judge improperly rewrites the law. There's this beautiful legal metaphor that warns a judge must not become a knight-errant roaming at will. In other words, judges cannot act like vigilantes, just making up their own rules because they happen to dislike a particular statutory outcome.
Looking at the Grunt case from 1948, Lord Green established the ultimate limitation on the Golden Rule. Yes, judges absolutely made apart from the literal meaning to avoid a genuine absurdity, but they have a very strict boundary line that they simply cannot cross. Lord Green famously cautioned that absurdity, much like public policy, is an unruly horse. He emphasized that the concept of absurdity must absolutely not be used to twist language or to rewrite a law in a way that makes it differ from how it was originally framed by the legislature. Remember, absurdity is not just an outcome a judge personally dislikes. The Golden Rule is a tool to uncover hidden legislative intent, not a free pass for judicial activism.
The Golden Rule prevents the law from becoming a dead letter, saving it from the rigid traps of its own grammar. But man, it asks a lot of the judiciary. I'm going to leave you with this provocative question to consider regarding this very delicate, high-stakes balance. In a complex, ever-changing world, where exactly is the line between faithfully interpreting the spirit of the law to prevent absurdity and crossing over into rewriting the law entirely? Thanks for joining me on this explainer.